So I'm only going to be on here for a couple of minutes. I'm just going to take attendance. We're going to deal with the cases that have one party here. And then the person who's normally scheduled to do this calendar has to deal with something in a different courtroom. Once I'm done with that, then he'll come on and finish out the calendar and actually hear the hearings. So first of all, Eric Blacksmith is on the Zoom call.
Yes, Your Honor, I am.
Hi there. And were you able to get service on Mr. Burnham?
Yes, Your Honor, I did.
Okay. Does that, hang on just a second. And Mr. Burnham is here? Okay, all right. On Ms. Burschauer?
Yes.
Hi there. So I know I wasn't expected to do the calendar here today, but I recognize you. You know, as I said before, I think that we're at the point where at this point, you know, I don't know if it makes any sense to renew it again because it's been renewed 5 times.
She was served.
Oh,
she was served. Yeah, there should be an civil department.
Just a minute.
Okay.
Just a minute.
We have not received.
We haven't got it.
Well, they sent me an email at 8:05 this morning telling me that everything was sent over to you or is on the file.
When did they send it?
Can I look? Let me look real quick and see if I can.
Do you have a copy?
Yes, sir, I do. A copy of the service or the email?
The service.
Yes, sir. It's sitting right here in front of me.
March 11th. It was this came in today. File TCDC. It came in this morning. All right, we have it here.
Thank you.
Is there a Caitlin O'Hara on the Zoom call or in courts? So Michael Johnson's not here. Did you say, ma'am, that he's going to be the subject of a competency?
Yes, he's in a competency hearing. It was supposed to be starting at 9 a.m. this morning as well.
All right, give me a minute.
Okay.
Does that involve interaction with you somehow?
It involved the same day in question.
Okay.
The same day of arrest that my protection order was issued.
Right. We'll come back to that in a minute, ma'am. Jose Letts or Leets, they're not here. Also respondent motion to terminate. Is Jose here?
Jose's not here. Joe is. I'm the second person on the restraining order. Both Gina and Jose have passed away.
Oh, Gina has passed away?
Yeah, it's in 2018.
Oh, I see. Why do you need it terminated at this point? Would that be?
Well, it's because for some reason when he's my stepbrother, he was arrested and he used my information initially. And then on the restraining order, it has both Joe and Jose on there. So they put my name on there 25 years ago and it's never been removed. So the whole process is just now to get it removed.
All right. So, all right, I'm going to step off. I'm going to communicate with the person who's actually going to hear all these cases. He's going to come on and address all these. But in the meantime, we still don't see Caitlin O'Hara, Michael Johnson, and Travis Tyrolls. All right.
Right person. Go ahead and be seated, please. Okay. Good morning. I have a few cases here that I'm going to go ahead and call that Judge Meyer alerted me are ready to be heard. So looking at the calendar, Ms. Burschauer, I understand that you were able to get service on Ms. O'Hara.
Yes, sir.
Okay, and then Ms. O'Hara has not responded.
The only response she did is set a fire at my house.
Okay. All right, and I'm mostly saying that for the record. Ms. O'Hara has not responded according to our records. And thank you, Kayla. I'm gonna check and make sure that we don't have a response from counsel either. It appears that we do not. Okay. Ms. Burschauer, I'm going to go ahead and grant your anti-harassment order,
Oh, thank you.
and that'll extend the protection from the temporary order for a year.
Okay.
And if you just going to have to bear with me a second here, because I have to make sure that the terms and conditions of the order that I issue here are the same as they were in the temporary order.
Okay.
All right, Ms. Burschauer, I've issued your order by default on the same terms and conditions as the temporary order, and that order is in effect for the next year from today. All right, the court clerk is going to file that, and it'll be available to you a little bit later today. All right, did Michael Johnson ever respond? Hey, you're welcome. All right, Alicia Henson.
Yes, sir.
All right. So I've got your petition here, and I understand that Michael Johnson has not responded. And this petition has been served on Mr. Johnson.
Correct.
So, all right, Ms. Henson, I'm going to issue the order by default.
Thank you.
And if you just bear with me a moment, because I need to make sure that the order that's issued here today is the same as the order that was issued originally.
Okay. Thank you, sir.
All right, Ms. Henson, I've issued the anti-harassment order on the same terms and conditions as the temporary order that was issued previously. That order is in effect for the next year from today.
Okay. And when it comes to expire, if I feel that my daughter and I still need that, do I just follow the same, come to the court? Okay.
Yep. If it's best, and it'll be smoother if that time comes that you file a request to renew it, be 30 days or more before it expires.
Okay. Okay.
Yeah. Good question. Yeah. Any other questions?
I just hope that he gets the help that he needs. My family's been through a lot.
All right. Understood.
Thank you.
All right. Henson.
Have a great day.
And You as well. All right.
Thanks.
All right. So that's a little bit different. But I've got the petition for the modification or recall of the previously issued anti-harassment order. All right. And you're Mr. Leite?
Lieutenant.
Leite,
Okay.
okay. All right. And I understand that from your petition that the petitioner that had originally filed this action is deceased, and that the other respondent is also deceased.
That was correct. And originally it happened because my stepbrother used my name. And if you look at the original petition, it has my name at the top and his name on the bottom. So I'd actually never even met the petitioner, nor have I ever seen her before in my life. So it wasn't until recently I found out that this is why I keep getting stopped every time I go through customs. So anyways, with both people no longer here, I would assume that it would be something that we could get removed altogether.
All right. Now, I don't have, I mean, I have your declaration, but other than that, I don't have any basis to enter findings that either of those parties is deceased. Typically what would happen is someone would submit something like a death certificate or a declaration. So a declaration like a county official who records deaths, that sort of thing.
All right. Minnesota doesn't allow to get a death certificate unless you're family. I don't know any of her family. Again, I don't know any of the parties there. The other thing is I mean, I always understood that with a restraining order, there had to be some sort of service. I was never notified. I was never served. I didn't even know it existed until 2012 and when I called the sheriff to find out what happened, that's when I found out my stepbrother, had used my identity when he was arrested. I didn't even know there was a restraining order even at that time. So it's the fact that it's, first of all, it's a lifetime restraining order is kind of crazy. In that, but there is no way for me to get a death certificate without contacting her family. And I can get one for my brother. He died in Idaho in 2021. She died in 2018. Regardless, I mean, to me, it seems that a lifetime for someone who's not even knowing of either person, well, the original petitioner, nor was I ever served. It seems a little silly to leave this in place. Again, since there is no one to be protected from.
I understand that. It makes sense, and from your point of view, that all hangs together. But I want you to bear with me here a second. Okay, all of this happened quite a long time ago, and there isn't any other, records or evidence to substantiate any of those things, which, I understand. So, like I said, normally in order to reverse an order, the court has to make certain findings, and there has to be evidence in order to make those findings. I'm not saying that evidence doesn't exist or can't be, found and put into the record, but right now, as we stand, it is not. So what I'm going to have you do, I'm going to take this motion and keep it alive for you, but you're going to need to substantiate those claims. So there's kind of two basic ones. I mean, the death of the parties, that's certainly a significant one. And I'm going to keep this open for you to submit evidence of that they have died. And then the second one is the identity issue. I mean, I know you're saying you never knew about it, you never heard about it, and I'm not telling you that you're wrong, but I'm telling you again that the record or evidence that substantiates that is not present. All I have is, records that were made 25 years ago. In order to
my name and birth date are not on any of those records you have from 25 years ago.
Yeah, and that exactly. So if you clarify this, then we can go back and we can make the required findings. We have the evidence to make the required findings to reverse this order that was put in place. That's what I can offer for you is you've raised an issue that obviously needs to be addressed, but in order to be able to make the appropriate rulings on it, there has to be the evidence for it. So I'll give you the opportunity to do that. So normally the way I do that is just, extend this hearing out to another date. You present that evidence and then we'll evaluate it. And if that's sufficient to overturn the prior findings or make the appropriate finding that circumstances have changed, then the order can be removed. So in order to do that, though, how much time do you think you need in order to be able to present some of that evidence?
I probably have to get a lawyer to get the death certificate since they won't give it to me since I'm not a family member in Minnesota. So it shouldn't take too long, but again, it's just a cost. This thing is just costing me money every time I turn around, and it's been a pain, if you can imagine, for 25 years. So,
okay. So would you like, say, 30 days to do
fine.
this? Okay.
Yeah, 30 days fine.
Okay, let's have a date for him to have it. Okay. April 15th.
Okay, tax day is fine.
That's a good way to remember it. Okay. And then you can supplement that record with any filings that you need to, if it's death certificates, declarations, obituaries. I mean, I'm not telling you how to do it. I'm just telling you generally these are the kind of things I would normally see in a motion like this.
Okay, I'll get that.
Okay, we'll see you in about 4 weeks then. Mr. Jose Leete. see him. He's the respondent, but he is the party who filed the motion to modify. And let's see, I know that the parties are both here. I just don't know who's who. So it looks like Mr. Blacksmith is there online. Good morning, sir. And you're Mr. Burnham? Yes, sir. Go ahead and have a seat. Motion to modify the order. So I'll just explain how I'm getting to where I'm getting here. Looks like there's some additional stuff that's been filed. Okay. All right. Okay, normally the way this works is this is a case where a anti-harassment order was previously issued by the court. I believe Judge Meyer did that. In order to put a case like this on the calendar for a modification of that order, it's required that the person seeking the modification file the appropriate motion and declarations, which was done here. And then there's a review by the judge for sufficient cause showing prior to a case being set on the calendar for a hearing. That middle part got skipped here. So this got set directly for a hearing, which I think kind of creates the impression that there's substantial cause to change the order. Now, I've reviewed the petition and the allegations that are made in it. And based on that, there is not a basis to modify the order. There are a couple of major reasons for this, but the primary one is that the request would be to severely and substantially limit the respondent's free speech rights. And the court can't do that in a modification order or in an anti-harassment order. So, Ms. Blacksmith, the truth is this case probably wouldn't have been calendared for a hearing if your submission had been reviewed by a judge for sufficiency rather than just set for a hearing. So I want you to understand, though, that I guess both of you to understand that the provisions of the order that Judge Meyer issued are still in effect, and they prohibit contact and communication, among other things, as it's written in the order. If you believe there's been a violation of any of those provisions, the thing you should do is report that to law enforcement, because they would be responsible for enforcing that. If you're concerned about the things that Mr. Burnham is saying about you or representations he's making to others about you, an anti-harassment order is not the vehicle for addressing that issue.
Your Honor, I did actually contact law enforcement, and law enforcement said because of the nature of the situation that it was really something that needed to be remanded to the court because they had concerns about First Amendment as well. My basis is not grounded with Mr. Burnham's freedom of speech. It's the continuing harassment that he's continuing to do towards me, which he's admitted to witnesses. I have witnesses with me that state that, yes, those signs are directed towards me, and he wants everybody to know, exactly the kind of person that I am. I've not actually been by Mr. Burnham's house at all. I've not harassed him in any way. I've not really even communicated to my neighbors what's going on because, well, I'd like this whole thing to end, but Mr. Burnham seems to be continuing to focus on the situation. And so I'm just here trying to figure out what my options are as well, whether I need to take this civilly to get a lawyer.
Mr. Blacksmith, if you want to know what your options are, I would suggest you consult counsel about that. But what you filed here is a motion to modify the existing order, and the request is to modify it in such a way that it wouldn't be a lawful order. So for that reason, the court should not have even placed the allegations on for a hearing. It sounds like law enforcement keyed into the same issues that I did on reviewing this, which I think is appropriate. But the answer to your issue may be something else. I think if you were to consult with counsel, you may come up with some other options that are more appropriate. But we can't convene a hearing to discuss options for how you can approach this. That isn't what a court hearing is for.
Understood, Your Honor.
Yeah. All right. So I am just going to sort of rewind this to the stage of not finding sufficient or proper grounds, a sufficient showing has not been made in order to place this on a calendar for modification. So that will just terminate the need for a hearing altogether. All right, and Mr. Vernum, we're not here to air grievances or.
No, I'm
discuss
not here to air grievances. I'm here to invoke my First Amendment, which Judge Buckley agreed with 18 years ago and 2 weeks ago, when my neighbors lied about me, 2 of them, and killed my daughter's dog 5 years after my daughter was murdered.
We're not here.
I realize that, but I have a First Amendment. I haven't used this man's name. I live a quarter mile away from
Mr.
him.
Vernum, we don't need to do this.
Well,
Like I said, we're not.
he's been harassing me. He calls the cops on me.
Mr. Vernum, we're not here for that either.
Well, that's fine. I'm done then.
Yes.
On November 6th, I can come and get my daughter's guns that they took.
I don't know. I don't have an answer for you. I don't know the answer
You see,
to that question.
Your Honor, I have a broken hand. I can't shoot a gun.
Mr. Vernum,
And this man's a liar.
I'm gonna move on to some
Okay,
other
I'm
business
done.
before the court.
I'm done.
All right, Mr. Blacksmith,
keep making my
that'll
signs,
conclude it
right,
for
Your
today.
Honor?
Like I said, Mr. Vernum, this isn't a
My
question
signs
and
are being
answer
made
period.
still.
I'm sorry, Your Honor. Did you have any further instructions? I could
No,
not-
there's nothing else.
Thank you, Your Honor.
All right, and are you Randy? You're Taylor?
When the other judge was taking attendance, I mentioned I wanted a continuance. I wasn't served
Go ahead and have a seat.
until Wednesday.
I'll get to that, I promise you. Okay. And Casey Ballou, you're here too?
Sorry, the Zoom's going to.
All right, yeah, you broke up there a little bit, Mr. Ballou. Are you able to hear me okay?
Yeah,
Okay.
I don't know why. I can hear you. Yes.
All right, so it looks like Mr. Taylor was served, and that proof of service was filed with the court today. And I'm going to take a look at the proof of service because that declaration will tell me when it was served. And it says here that it was served on March 6th, which would have been Wednesday, right? Okay. So, yeah, Wednesday. Yeah.
At 10:30 p.m.
Gotcha. Okay. And Mr. Taylor, you have raised the issue that you may need more time to respond to this.
And I thought it was kind of strange because they only served me the order, not the
You
petition,
didn't get the
and
petition.
none of the evidence.
Okay.
When I came to the courthouse and got the petition, they said they're not giving me the evidence, that I had to do it all myself online. And it says right on the orders that the law enforcement should give me all of those things.
So-
And the courthouse wouldn't even give me the evidence.
Okay. This doesn't even say what was served on you. It says the temporary protection order and notice of hearing was served on you, but not the petition.
Or the evidence.
All right. Yeah, the evidence is in the court file. That doesn't typically get served. But the petition and the petition gives you the notice, of course, tells you about the hearing. The petition tells you what the allegations brought against you were, right? What the other party said about you. So you're on notice about that. And then evidence is placed by the parties in the court file, and it's made available for each party to see and inspect and so forth and prepare for the hearing. So it's not something the law enforcement gives to you.
And how come on the form it says that?
Don't know.
It's like something page 8 or something, 11 or something like that. It says all those things are supposed to be in served.
Yeah, I don't know. Anything that was filed as part of the petition would be served. But there's other things besides what's filed with the petition that may have been filed later.
Sure.
I don't know. I don't have the answer.
But I mean, I
that
thought
question here.
not getting the petition was strange as well.
Okay. So kind of cutting through that, the main issue I think you were bringing up when you originally sat down was you feel like you didn't get enough time to prepare for this.
Thursday and Friday and the weekend.
Yeah. Okay, so do you need more time?
Yes, sir.
Okay, how much more time do you need?
I do.
To be on, he was served notice for the order,
Mr. Blue,
back in beginning of.
I haven't
So-
finished here, Mr. Taylor, yet. I'll give you your turn to respond to that in just a second, okay? All right, so I'm sorry. I was gonna ask you, how much time do you think you need to be ready to respond to that?
1 more week.
Just one more week, okay? So,
And I did have something taped on my gate the prior week. And I came here and tried to get some stuff. And they said I wasn't served until the sheriff served me.
okay. All right, well, let's see what we can do. All right. So Mr. Baloo, Mr. Taylor is asking the court to extend your hearing for an additional week so he can be ready to respond to the petition. So what do you think about that? And your microphone's currently muted.
Question when you're done.
I believe it's that he knew what was that he was being served, as evidence shows that he had knowledge weeks prior to being officially served. He just avoided any contact with law enforcement. But I will go with whatever you decide to do today.
Okay. All right. Well, I mean, a week's not a lot to ask. And I think it seems fair to me if you were served on Wednesday. I mean, technically, maybe we could say, well, there was 5 days and that's enough, but that's kind of marginal. And if you also haven't had a chance to inspect any of the material in the court file, then probably be better if you got to see that first before you had to respond to it. So I think we can probably do that. The calendar on the 18th wasn't too full, was it? I didn't think it was. Okay, well then we can do that. We can go out 1 week. And so what I'll do is extend the order that was previously issued, and that'll just remain in effect for the next week until we hear from both of you and make a decision, okay? Okay, go ahead now.
So having a week more, when do I have to file anything I want to file by? What's my cutoff date? Because I only get that many days really to do.
Thursday would be the normal cutoff there, the filing deadline.
That's really how much time I really get is from now till Thursday.
Well, to submit your own stuff.
Yeah.
There shouldn't be much. I mean, you can file it, file it by Thursday. That gives him a chance to see it too. But do keep in mind though that this isn't like if you've ever done any civil litigation before, this isn't like a discovery procedure.
I just have some superior stuff, family type stuff a little bit.
I don't think I can get a word in edgewise here. All right, never mind. Your order is extended for a week. Your notice for that next hearing is right here. I hope you have enough time to review everything and be ready next Monday, and we'll finish this up.
Absolutely. All right, thank you.
Okay, that's for you. All right, thank you, Mr. Baloo. We had previously continued this case.
Can you hear me, sir?
That was because Mr. Taylor had needed some time to respond. And it looks like you did file some responses late last week, so we've received those and had an opportunity to review them. So, Mr. Baloo, are you ready to go ahead with your hearing?
I believe, yes.
Okay, and Mr. Taylor, are you ready too?
Yes, Your Honor.
Okay. All right, then, Mr. Baloo, as the petitioner, you get to go first, so you can go ahead and present your case. And keep in mind that everything that you've previously written or filed in this case is already part of the record. Go ahead, sir.
I'm filing this because ending the friendship that was no longer conducive to both of us. I have since then been my house place of work has been intruded upon. And all I've asked of Mr. Taylor is to just drop everything and just leave me and my family alone. I'm tired of my parents being stressed out by the fact that some of the actions that has happened, presented with evidence presented of thought being followed, showed up at places of work, school, other activities, and all I want and have asked since then is to just please just leave me alone. And that's pretty much all I would want is just to no more contact anymore. Yeah. It's been incredibly stressful for again me and my family. I am tired of wondering if they're going to be showing up at my place of work or wherever else I am. That's essentially it. I just wanted to drop it.
Okay. All right. I think I do understand the nature of your request. So if there isn't anything further you want to add, I'll hear from Mr. Taylor and make a decision. Okay.
Yeah, sure.
Okay. Mr. Taylor.
My anxiety's a little off the board today, so I'll try the best I can.
Mm-hmm.
I was just a little confused with Mr. Blue's thoughts when he's filling out the petition with, he said, he marked the part, about the firearms and like not to take them away or prevent me from getting more. I mean, if someone was really like worried, wouldn't they like say yes on that? And another one there. My thoughts are all over the board. I'm sorry. And clearly, he marked us as friends, and clearly it was more than friends. He does a lot of puts something in front of you and pull it away. Puts something in front of you and pull it away. For instance, 4 to 6 weeks before he decided it was over, he gives me this long speech when we're driving around his mom's truck about how if something ever happened, he had never walked completely out of my life. He'd always be some sort of a friend of some sort. It's like he was setting everything up for this day or something. I also noticed on his petition, he says that he had to seek counseling for the mental anguish and whatnot. And his counseling was started before that, and I submitted a text where we were talking about it to prove that it was before that. So it's not because of the day we broke up. It's because he has a lot of his own stuff going on. We both have a lot of our own stuff going on. And we kind of understood each other's stuff going on. And then like he's learned it all to use it against me. He has multiple profiles online. He says I'm the one with multiple profiles and harassing him. He has 8 that I know of that are his, and I'm sure there's a couple more. And that's just in one platform website. He wants his privacy and to be left alone. We're using a platform website that's map-based. It shows your picture and icon on a literal map of where you are. And it shows everybody where you are. So I don't understand how I'm seeking him out and stalking him when we're both doing the same thing. We're on the site to find somebody. And our icons are shown where we are on a map. Like, I don't understand. You can't go on the site to try and find somebody and not see each other. This gay community is very small. Olympia, it's not real big. We wind up with the same people in and out and back and forth. His ex's roommate picked me up downtown and took me back to his apartment, not knowing that he was at his ex's house that night. And then, like we run into each other. Like it's gonna happen, it's inevitable. And I'm willing to be civil and a girl and like, hey, on our merry way. But anytime and every time I have wound up somewhere where Mr. Blue is, he goes ballistic and screams and yells at me. But I'm the one who's being crazy, according to Mr. Blue. Friends have said I should file on him, including Tuckman. It's like, I'm trying to not ruin things. He knows with this on my record, I'll lose my career. He has threatened me multiple times during our relationship friend or not, whatever he wants to call it. If I didn't do something or if I did something a certain way, he'd either file APS on me or he would call the police on me. And like the night at the ex's house, and he ripped my keys out of my hand, pried my door open to my car. He has a set of my house keys. I had to get a locksmith out so I could get in my house. He's like, I didn't pay for any of that. It all started it, but okay. Because it's kind of everything he's accused me of, he's doing to me. Apparently, I care more than him, and I want him to be happy. I want him to have a good life. I want him to go on, but we are going to cross paths. We are going to, eventually, it's going to happen again. And if he gets his order, how, you know, like, I mean, I could turn around and get one too, you know, like, and then we both can't go anywhere. We can't do anything. Like, maybe adults can get along and just like, I mean, I have a whole bunch of stuff right here. I could read it all. It just seems silly and ridiculous to me, Howard.
Well, obviously, this is a little bit of a difficult and fraught situation for both of you. It's obviously, as far as I can see here, causing both of you a pretty good deal of stress. But the way I need to look at this is whether or not, you know, whether or not Mr. Blue is the petitioner. So I need to look at whether or not he has established that he's entitled to an order for any of the various bases that there are to get one, including stalking, which I think is the one that he had identified that he was after. And so I have to look at the facts as alleged by both of you, make credibility determination, and consider whether or not what Mr. Blue is alleging has occurred here would constitute stalking. And you know, Mr. Taylor, you point out, and I think reasonably, that, you know, it's a small community here in Olympia. People are going to run into each other. That's, you know, not anything that only happens if somebody's being stalked. That's just the kind of thing that happens by chance. And, you know, when you consider your social groups and your interests and your, you know, what restaurants you go to, you know, things like that, then those chances increase, you know, because you're talking about a smaller and smaller group each time you consider those things. So yeah, you're right. I mean, people are going to run into each other in a town this size, and that's not any kind of, in and of itself, that's not any kind of a violation. That's not even a violation of the protection. But what I'm looking at is not coincidental things like that. I'm looking at intentional things. So in other words, is the conduct that's alleged here the kind of thing that displays an intent to stalk another person? And by that I mean getting in contact with them, showing up where they are, letting them basically know that they're being tracked or watched. And is that sort of conduct or activity, would that cause a reasonable person to be in fear for their safety? And I think that's what Mr. Blue is saying, is that's what he thinks is going on. And that's the evidence that he's submitted to support that. So in any situation, any person, whether or not there's any, you know, criminal conduct going on or anything like that, you know, they've got the right to not be contacted by another person if it's harmful to them. Anyone can do that. Just tell a person, don't call me, don't come by, none of that. And if somebody honors that request, then fine, there's not a problem. But it's the contact that occurs despite that making plain that they don't want it. So, you know, my concern here is that, Mr. Taylor, my concern is that what's happened here is that after the end of the relationship, as Mr. Blue characterizes it, that there was a continuing effort to remain in contact and to display to Mr. Blue that despite whatever he may want, that there would still be contact initiated by you. That's what I'm looking at. I'm not looking at whether you're going to show up together in the same places or that you know the same people and that sort of thing. Yeah. So did you have something you needed to say?
The evidence I submitted, it shows, like on the 12th, I wrote him an I'm done goodbye letter. And then on the 24th, he reaches out to me and he starts it again. He reaches out to me. He's contacting me. Like
no, I saw that.
He's done that multiple times through the relationship before the breakup. He's said, you know, don't talk to me, and then he reaches out to me again. I think there was another one December 31st to January 3rd, where he reached out to me and he was like, hey, and I was like, why are you reaching out to me? Like, I was done. Like, why did you say hey last night?
That was before any of this happened.
So
it was very common throughout our friendship to hear those things. It's not like, you know, it was never said, then it said once, and it was said common. It was very common.
all right. And I get that, Mr. Taylor, and it's not altogether uncommon to hear those things in a situation where somebody is being stalked. If they are, then you know to point to a response to a text or a response to a contact and say, well, that's evidence that they don't really want me not to contact them because they're reaching back out. That may or may not be true. It depends on the context. So I've got to decide this based on the strength of the evidence. In other words, Mr. Ballew's got to show by a preponderance of the evidence, the greater weight of the evidence, that he's entitled to this order. And this is a close one because, you know, Mr. Taylor, you're offering up explanations for, you know, the course of conduct that's happened after the end of the relationship that, you know, that are reasonable explanations, that are non-threatening, that are just normal things that happen, as you said. And you know, Mr. Ballew is saying, no, they're not just coincidences. They're designed to, you know, basically intimidate me. That's his position. And like I said, this is a close call, and I'm mindful that if an order is to be issued, that imposes significant restrictions on another person, potentially subjecting them to, you know, criminal consequences. So that's why the law requires that the person who's asking for an order has to show by a preponderance of the evidence that they're entitled to one. And you know, Mr. Taylor, a lot of what you say is reasonable and makes sense to me. So you've also said that you aren't interested in having any further contact with Mr. Ballew. So what I'm going to do is, on the balance here, find that Mr. Ballew has not carried the burden of showing by preponderance of the evidence that stalking has occurred. And I will decline to issue an order. So the temporary order will end today. But I will say this: if there's any further unwanted contact, you know, if a pattern continues or develops that shows that Mr. Ballew is continuing to receive unwanted contact or unwanted surveillance, that would show perhaps that there is such stalking going on.
The evidence that has already been submitted has shown multiple instances of vague threats, multiple changing of phone numbers, and showing up non-coincidentally at the places that I have been to. And yeah, I understand the whole small community part, but I don't intentionally. I haven't gone anywhere near them in this entire time, and yet I had multiple instances of him showing up at specific times at specific places where I am, and I've asked him to please just leave me alone. I don't want, you know, I'm not trying to ruin his career, but I have asked him multiple times, and my parents' health is being affected by this more than anything, because they're afraid of what is, you know, him sending pictures of my house at whatever time when he's not supposed to be there.
I've heard from both of you. I've read all of the substantial information that's been filed by both of you in support and against the issuance of this stalking order, and I made the ruling that I have. It's like I said, it's a close case. It's kind of, you know, you both seem equally credible to me. You both seem equally concerned about, you know, the situation, and I also think, from what I've heard, that neither one of you wants any further contact except, you know, as you said, it could coincidentally. So on that basis, based on that evidentiary standard, that's my ruling for today. But also, like I said, there should be, if there are, that will be. Okay. So today.
Sure.
All right. I've written that order to the effect of what I just said. And that the clerk will file that today, and you're both able to get copies of that order from the court clerk.
From the office over there?
Yeah, you can, yes, you can get it from the office. You can get it online, be filed and available online too. So, yeah. All right.
I can request an email to me.
Excuse me. I'm sorry, Mr. Blue, I didn't catch that last.
And online, I can have them email me the ruling.
Correct. Just reach out to the clerk's office.
Thank you.
It might be a little while because the clerk's in court with me right now, but later today. All right. And I'm showing, Mr. Emmett, can you confirm for me that you're ready to go with your hearing today?
Yes, I'm ready.
Okay. I reviewed the record and saw that you had been served with notice. All right. And then Ms. Pierpoint, are you ready to go as well?
I am, Your Honor. Thank you.
Okay. All right. What I'll do is I'll swear you both in, and then I'll hear from Ms. Pierpoint first, and then I'll hear from Mr. Emick after that. Keep in mind that I've already read your petition and everything that's in the record. It's not necessary for you to repeat any of that. You're not required to repeat everything that you've already done in writing, is what I'm telling you. And any of those things that have previously been filed are part of the record in the case and can be used as part of the decision as to whether or not to issue the order. And so feel free to refer me to any of those documents or other exhibits if you want to. And then please, you saw what happened at the last discussion. It only works if one person at a time talks, and interrupting each other is obviously not effective. And it's, I just don't think it works. So keep that in mind, and keep in mind that you get to address the court fully on your issue, and then you get a chance to respond fully. So even if the other party says things that you don't agree are true, it's not necessary to interrupt them. Just keep in mind you get to tell your side of it. They get to tell their side of it. That's how it works. All right, Ms. Pierpoint, go ahead.
Hi, Your Honor. Thank you for your time today. I am here to request the approval of my petition for a protection order against Mr. Emick. I am moving forward with this anti-harassment order at the suggestion of law enforcement after an incident on February 24th that resulted in Mr. Emick physically assaulting my husband and I on our property. This event can be found in more detail on pages 10 and 11 of the petition. Unfortunately, law enforcement was unable to charge Mr. Emick because we did not have obvious physical injuries, and Mr. Emick would not answer his door when they arrived to question him. Mr. Emick has exhibited a pattern of behavior that is seriously alarming and concerning. He's been made aware of this behavior, and not only has it continued, but it is now escalated to physical assault. It's clear that Mr. Emick is retaliating in response to violations that he has been found guilty of on his property. He appears to be encouraging and recruiting family and friends to join him in this behavior as well. Mr. Emick's behaviors and actions are well known in the neighborhood. He has had altercations with several other neighbors. This has become serious enough that 6 families have come together to meet and discuss their concerns about Mr. Emick after an incident in which a camper was set on fire with propane tanks inside that caused several large explosions and resulted in a brush fire that quickly spread on Mr. Emick's property. Thankfully, this fire was extinguished by the fire department, but that was only after neighbors called emergency services. After our daughter's bedroom window was broken, the responding officers recommended we install lights and cameras for security. We inquired with them about the placement of the lights and the cameras, and they gave us their suggestions. We followed their suggestions, and on February 24th, when officers arrived at our home, we again confirmed that our cameras and lights were following Washington state laws. Sheriff's Deputy Zamora stated we were well within our legal right to protect ourselves and our property. Throughout this ordeal, I have never contacted Mr. Emick via phone, email, text, or in person. I have never confronted him, and I have never returned his offensive gestures. In fact, I have not spoken to Mr. Emick since August of 2020. So I'm seeking this order of protection to ensure the safety of my children and myself, and to create a clear boundary for Mr. Emick, as well as the ability to pursue legal action in the future should his behavior not stop. It's my hope that this order of protection will diffuse the situation and prevent future incidents with Mr. Emick and third parties on his property. So thank you again for your time and assistance in this matter today, Your Honor. It is greatly appreciated.
All right, Mr. Emick, you want to go ahead with your response?
Yeah, the night she is talking about, I believe it's the February 24th. Yeah, we went over to the fence. They were blasting very loud music. So we walked over there to see what was going on because we couldn't even see them. and they started actually hitting us with sticks over the fence. So I'm not sure what she's talking about of us assaulting them. I reached over to try to grab the stick out of his hand while he was hitting me and my friends, which were on my property. So that's that incident. I don't know what else I need to defend. The fire she's talking, I'm not sure if I'm supposed to explain everything that she's lying about. The fire she's talking about is something my girlfriend had to do with. She's on the fire department record. She got the ticket for it. I had nothing to do with it. They've been after me. They have lights blaring 300 feet over my whole property. Did you get documentation that I filed? I filed like 30.
I have, yeah, I do. I
41
have
pieces of evidence. Once this goes through, I'm actually going to file a harassment order on her because I'm not really sure what they think I'm harassing them with. I didn't break their window. We were actually in OMAC that weekend. I have proof of that. Hotel records. We weren't even home. I showed all the text messages that her husband has sent to me, how violent they are. If they had another text message from me, I guarantee you they would have presented it. I don't text them back. I don't harass them. I can't see their property. I built a secondary fence just so I don't have to see them. They shot my truck window out with a BB gun. I called the sheriff. I have documentation of that. He said I can't do anything unless it's on camera. But my truck happened to be right next to the property line, facing right where, it's pretty obvious. They've called the county on me. They've called ORC on me, even if my neighbors are burning. I don't really know how to, I don't know if anything I'm saying is pertinent to this case. It's pertinent to them harassing me, but in no way do I harass them. I'd like to know how I'm harassing them.
Is there anything else, Mr. Emick?
That's it.
All right,
like you said, I have not seen her in 4 years. I don't see their kids.
I'm sorry that there's a difficult relationship between neighbors here. That's always a tough.
And one of the items on 1/13/2024, I'm up in a tree, about 15 feet up in a tree, 130 feet away from my fence, putting up an antenna so we can watch football. He comes out on these stairs and he just starts filming me. That's what they do. They have these stairs that overlook my property and they constantly film me. And yes, we do flip off their cameras because their cameras are invading our privacy and they look about 200 to 300 feet over our property. And I'm looking into hiring a lawyer to deal with all this once we go through with whatever happens here.
Okay, can I have a... Thank you. All right. Well, I do find Ms. Pierpoint's allegations of harassment to be credible, and they're consistent with what was placed in her petition originally in this case. Ordinarily, conflict between neighbors is not the kind of thing that's going to result in issuing an anti-harassment order. People are not required to get along. People are not required to be nice. People are also allowed to express their displeasure with each other and even do that in ways that can be offensive or really unpleasant. But lines can be crossed, and lines can be crossed when threats are made. Lines can be crossed when physical violence occurs or property damage occurs or attempts to do those things. And it appears to me that what Ms. Pierpoint is saying is credible with regard to physical assaults and damages. And I'm finding that the allegations that she's made in her petition and repeated here today are credible. And I think those form the basis to find that there's been a pattern of behavior directed at her and that behavior is serving no lawful purpose and is also harmful to her physical or mental well-being, and any reasonable person would suffer the same kind of harm. So I'm going to issue the order, which really means what I'm doing is extending the order that was issued on a temporary basis for a year.
Can you
on
explain
the same terms and conditions?
Can you explain to me how I'm harassing them? What am I actually doing?
All right, I've done that. I've made my ruling and I've explained it, and that is the ruling of the court.
What am I restricted from doing?
So I'll explain that part of this in just a moment.
Am I able to file a harassment order against her still?
All right, this order just prohibits the same things that temporary order did. which is to say no harm, no contact, and no approaching the protected person's residence or the person themselves. However, this restriction does not exclude the respondent from his own property or residence. And this order will be in effect for 1 year from today's date. That's to say March 11th of 2025. All right, this order will be filed by the court clerk today, and it'll be available to both of you shortly.
Thank you, Your Honor.
Can I continue asking questions? Or, Your Honor, I'm just wondering what I'm restricted from to do on my own property. I can go in, like, there's not a set limit on how close I can be to my fence line, right? Or
no.
Okay.
No, there's no such restriction.
Am I able to still file a harassment order on them to get them to remove their lights and cameras?
You have not been restricted from doing anything like that.
Okay, I just didn't know because of now she has this harassment order on me if I can file one on her. Thank you.
All right. All right, that'll conclude your hearing for today.
Thank you.
Thank you.
My place. You're welcome.
Excuse me?
There we go. Who is this?
I'm a witness for Carol Solar.
Okay. Did you need something?
No, I just wanted to make sure that
Okay.
I was here.
All right. No, we know you're here. We can see you. All right. Get there. Now I'm to the place I need to be. So again, what I'll do is start by swearing you both in. Ms. Solar, you'll be able to tell your side first, and then Ms. Hauser, you either respond. And again, keep in mind that everything that you filed written up to now is already part of the court record, and I've reviewed it, so it's not necessary to repeat everything in order to have me consider it.
Yeah, I'm not sure how far back I should go.
Okay, thank you. All right, and so Ms. Solar, go right ahead.
Okay, we met at the Tenino Food Bank. Sharon said she was autistic, and I told her that my daughter, who is here, is also autistic. And she said she could help my daughter, and she asked me also to help her at the food bank, which I did. Anyway, then there was a Christmas party that she asked me to co-host. She did not just invite me, she asked me to co-host it because she was a little afraid to do it on her own. So I agreed, and my daughter and I came to her house and we talked about it. And, you know, things that she would want to give the guests and such. And so the day came and I brought food, mac and cheese, and everything seemed to be fine. Well, anyway, prior to that, she was concerned about where the guests were going to sit. And I told her that I had a folding table that she could use. This is, to be honest with you, it's a ridiculous situation. Anyway, so while I was there, I overheard, I think she's another coworker that she used to work with, talk about her putting holes in her walls at home. And Sharon responds to, I was just mad. And I didn't say anything. I just overheard this. Anyway, the first day I met Sharon, I gave her a crystal as kind of a token for our new friendship. And then at the party, I gave her cognac glasses, crystal shells, and driftwood. So anyway, she put scratch tickets in her little boxes for her guests. And after all the guests had left, my daughter and I were still there. And Sharon, who I watched the video because I apologize, I didn't show up at court last time because I got the time wrong. And my daughter had been here at 1:30 instead of 9 o'clock in the morning. So I was told I could view it on video. Sharon offered her tickets to my daughter and said, thank you for helping with the party. My daughter never asked her for those tickets. And I told her she could borrow my table until she got another one. Let's see. Sharon exhibits fearfulness of objects. I witnessed this at the party. And the last time I was at her house, she said her ex-husband brought something over and she couldn't handle it. She put it in another room because she's terrified of the essence or whatever. And I also witnessed her hitting her dog and her dog's ears were down, and the dog kept on wanting to play with me. And she said, hit the dog in the nose. And I said, no, I don't want to do that. The same day she offered me Xanax, which I didn't want. And then later on, she said she wanted to quit smoking pot, and I was also a pot smoker. And she told me that if she quit smoking marijuana, she wouldn't be able to talk to anybody for 2 weeks. So I didn't call her for 2 weeks. But prior to that, I'm sorry, I'm getting mixed up. Before I left her house, which was the last time I saw her prior to her coming to my house, I saw a hole in her door, and I said, how did this happen? She says, I got mad. And I said, you shouldn't really be destroying your own house. And I said it nicely, but I think she got irritated and basically told me to leave. And the reason I was there in the first place was because she said she was sick. And I offered to bring her food from the Tenino Food Bank. She hasn't come here to my house since or called me. But I also believe that's true because there was a temporary order of protection and then she got served again. I do worry about my safety because I have balancing issues, and she is clearly an angry person. But when you first meet Sharon, she seems like a very nice person. And she told me she could help my daughter with autism. That's how we started our relationship. And while she was in court last time, she told the judge that she was fearful of my daughter. And my daughter is a sweet young lady, never hurt anybody. She's a high-functioning autistic person. And over a silly table, she wouldn't go after this woman. And as far as phone calls are concerned, I waited 14 days before I called her after leaving her house the last time. I respected her because she wanted to quit smoking marijuana, so I gave her the 2 weeks and an extra, well, the 2 weeks. And I called the first phone call. I said, hi, Sharon, give me a call. I waited a while, and then I called again because I figured it's time to get my table back. And I called her again, and I said, Sharon, give me a call. And then I noticed that the answering machine had changed. So at that point, I knew she was ignoring my calls. So then I called her again, and I said, Sharon, I can't really afford to give you the table. Nobody dislikes you. If you don't want to see us, just leave it outside and we'll pick it up. We won't even knock on your door. And anyway, pretty soon I got a knock on my door, bashing, and she was screaming at me at the top of her lungs, where most of my neighbors, I think, were gone. But anyway, she was screaming and yelling at me and telling me not to call her again. And if she saw me, she was going to beat me up. And she was going to call the police. And I couldn't get a word in edgewise because she wouldn't stop screaming and yelling. And by the time she left, I was shaking. And I called the police and I told them what happened. And then I don't know if it was the same day or the next day, but I called the senior center, which is another thing. When I first met her, I donated to the auction of the senior center. So I've been nothing but nice to this woman. And I had asked the director there if I should have any reason to be fearful of Sharon. And the woman got annoyed with me, and I said, well, thank you very much, and I hung up. And at that point, I just got the anti-harassment order. And as far as my son is concerned, he is in an Arizona prison, jail. Unfortunately, he's had drug issues for many years. He's not even getting out till July, and when he does get out, he will be extradited to Illinois. So her claims of my children harming her is ridiculous. And I have balancing issues. I know I'm twice the weight of her, but I do have balancing issues. I have numbness on my left foot. I have a hip replacement. And if I had to quickly get away from somebody or be even slightly pushed, even in my own home, I lose my balance. And I feel that I don't want to see her at the Tenino Food Bank. She lives in Yelm, and there's plenty of food banks there. And I just don't want her around me, to be honest with you. I think that's all I have to say.
Okay. So we're, yeah, I'm gonna be honest with you about my evaluation of this. I really don't see any harassment here. I'm
Okay,
having a real hard time seeing anything that could be considered legal harassment. I had that concern when I read the petition.
Yeah.
I wanted to hear from you to see if, not, people aren't always good at expressing things in writing, and sometimes
Yeah, I
they do
was
it better
quickly-
by talking about it.
yeah,
Which is what you've done here. And, I think I can confidently say as a result of hearing all this and reading all this is maybe Ms. Hauser isn't really pleasant. She might be a little bit difficult. But there's nothing about this that gives me the impression that she is doing any kind of, I guess from a legal point of view, a pattern of conduct that's directed at you that would seriously injure or harass or harm you. It doesn't seem that way at all. What it seems like is that you have a disagreement with her over, the way she treats her dog, the way she treats her property, how willing she is to communicate with you when you feel you have something you need to discuss. And I get that can be irritating and difficult, especially since it sounds to me like you were trying to kind of reach out and be friendly and, maybe strike up a friendship, with her, but that didn't work out. And maybe she just doesn't reciprocate. I don't know. But I'm not gonna require her to answer any of this because I still don't, even after you've presented it in writing, even after you've presented it, here orally, I just can't make the legal finding that what she did constitutes harassment.
may I say one more thing?
Sure.
I had a feeling that I would not get the order, and I'm okay with that. The main reason I came back here today was to defend my daughter. My daughter is a
Sure.
very sweet, loving young lady with autism.
Yeah, and that's, perfectly understandable. I mean, we all want to, defend our kids and, clearly she's his Jillian, right?
Yeah,
Yeah, I read about her in here. She's, I think that's a natural thing for a parent to do.
thank you.
Yeah. So I guess maybe I'll leave you with this. Maybe, as unfortunate as it is, maybe there's just no kind of friendship or relationship to be had here. So, don't reach out to her. Just, focus another direction and you all just live your lives separately from each other.
That sounds good.
Okay.
Thank you.
All right, you're welcome. I have signed the order. The court clerk will place it in the court file and you can each get a copy of it whenever you'd like.
Where do we get a copy?
She's gonna file it online, but I think
Oh.
she might be able to copy it right here for you since you're standing right here and
Oh,
you can
okay.
get a copy before you go.
Thanks.
But it just says that there's not any kind of order issued in this case.
Thank you, Your Honor.
You're welcome. I'm gonna make my way over to courtroom 1, so that'll complete the order hearings for today.